research from Dr. April Zioli, who I know is on this webinar and the best ERPO researcher in Michigan for sure and around the country. So we're also going to dive into Michigan's law and then get to some ERPO recommendations from a report that we released, the Center for Gun Violence Solutions and Everytown for Gun Safety in May 2023. And I want to also shout out Ruhi Bengali, who was the fourth author on that report, along with Chelsea Spencer and myself. So shout out to Ruhi for her amazing ERPO work as well. So what are extreme risk protection orders? You may have heard them called red flag laws or extreme risk laws. That's a phrase that's used to describe this law as well. But these are a tool to proactively intervene and prevent gun violence. So I will get into specifically how that's done, and Chelsea will talk specifically about Michigan's law. But just so you know, this is a law that exists in 21 states and the District of Columbia, and I have a map on the next slide. And although we haven't had these laws around the country for too long, California passed the first modern day version of an ERPO law in 2014, almost 10 years ago, and it went into effect in 2016. So we have 8 or so years of data on their use, but we do have studies that predate California's law, looking at Connecticut and Indiana, who passed a pre-modern day version of an ERPO law called a risk warrant law. And so we'll get into what the data shows us now about how they're being used to prevent gun violence. As you can see here, we have a map of the 21 states and DC that now have extreme risk protection orders. You all, of course, passed your law last year. It goes into effect in just a couple weeks, about almost exactly 2 weeks from today. And your sort of neighbor in the Midwest, Minnesota's law went into effect January 1st of this year. So those are the 2 newest states to pass an extreme risk protection order. The rest of the orders were passed prior to, of course, 2023. So what are extreme risk protection orders? They are civil protection orders that are modeled off of domestic violence protection orders, which exist in every single state in the District of Columbia and are a way to prevent domestic abusers from accessing firearms, but there are a whole host of other protections depending on the state that you live in. I will note that every state's ERPO law is slightly different. Every state's domestic violence protection order law is slightly different, but the component of them are similar in that there's usually an ex parte order or a temporary order that can address that real acute risk of violence, and then a final order, with finals really being in quotes because it's not final. It lasts typically up to a year for the extreme risk protection orders. There are a few key differences between domestic violence protection orders and extreme risk protection orders. The first being that ERPOs solely address access to firearms. So this is a tool that can be used to temporarily remove a firearm from someone at risk of harm, either suicide or interpersonal violence or both, and can also make sure that someone can't purchase a firearm as well. So it will temporarily remove a firearm and prevent purchase while the order is in effect. Now, firearm components can be in a state's domestic violence protection order, and it's actually very important when we look at the data of preventing injuries and fatalities that we do have a firearm component. But domestic violence protection orders offer a whole host of other reliefs related to no contact orders, stay away orders. There can be economic support involved. And so a big key difference, the first one I want you all to take away, is that ERPOs are about firearms and DVPOs can be, but have a whole host of other reliefs that are offered for victims and survivors. Another key difference in ERPOs and domestic violence protection orders is the petitioners. For extreme risk protection orders, every state allows law enforcement to petition for an extreme risk protection order. Of course, law enforcement cannot petition for a domestic violence protection order. But most states, including Michigan, and again, Chelsea will dive deep on this, most states have expanded their petitioners beyond law enforcement, typically family, household members, and in a growing number of states, healthcare providers as well. And we'll talk a little bit about why that's important and why we believe that petitioners should not just include law enforcement. And so I think I can speak for Chelsea and Spencer that we're glad that the Michigan law goes further. I want to also make a note about the intersection or lack thereof between gun violence and mental illness. A lot of media coverage, and it has gotten better, but a lot of media coverage, early media coverage about mass shootings or gun violence generally focused on mental illness as this root cause or cause of gun violence. But when we brought together experts, and when our co-director of our center, Josh Horowitz, brought together experts to talk about this intersection, they learned, and we learned, that mental illness or a mental health diagnosis is really not a good predictor of violence, particularly interpersonal violence. And in fact, individuals living with mental illness are more likely to be victims of violence than perpetrators. And so when we're talking about factors to consider for an extreme risk protection order, we really caution against using a mental health diagnosis alone as a reason for why someone might want an extreme risk protection order. We will talk a lot about the evidence that a judge should consider and some of those more evidence-based factors. And Chelsea has a list of what the factors to consider in Michigan are. But I just want to caution against connecting gun violence and mental illness, because it does stigmatize those living with mental illness. And when we look at the data, it's not a good predictor of future violence. We do have promising evidence on the use of ERPOs for suicide prevention. As I mentioned, we typically look to Connecticut and Indiana as those early ERPO state adopters. And research from Jeff Swanson estimated that for every 10 to 20 firearms removed, one suicide was prevented. Every 10 to 20 firearm removals or ERPO law, one suicide was prevented. And this is important to talk about because when we're looking specifically at suicides in this country, we know that means really, really, really do matter. And so if you look here on the right, we have a chart of the method. This is from a study that came out in 2019. So it was looking at 2007 to 2014 data, but looking at the percent of fatalities, basically the case fatality rate using specific means. And as you can see here, firearms are by far the most fatal. When you attempt suicide with a firearm, it's almost always lethal, as opposed to the other methods listed here. And so putting that time and space between someone seeking to buy a firearm or use a firearm and that suicidal ideation, putting that time and space between the individual and the firearm can really be the difference between life and death. There's a lot of research on this topic, particularly on the role of firearms in suicide, and there is emerging research on ERPOs and suicide prevention as well. And we have a lot of case studies at this point, a few of which are included in our slides here. I also want to call attention to Dr. Zioli's study on extreme risk protection orders and mass shootings, because we also have data from their 6-state, multi-state ERPO study about how ERPOs are being used to prevent mass shootings. And again, that depends on the definition used, but in this study, they used the definition of a threat to shoot at least 3 people. So when they looked at more than 6,500 ERPO cases in 6 states, they found that about 10% of the ERPO petitions were filed in response to a threat to shoot at least 3 people. Some of those targets were K-12 schools, businesses, and of course, intimate partners, children, their families. We know about the connection between domestic violence and mass shootings as well. Another interesting finding from this study, and I know it might be kind of blurry here, but we can put a link in the chat as well if you're interested in reading this study in full, is that judges did grant the orders in an overwhelming majority of cases here. That does not mean they were granting orders willy-nilly. There had to be the threshold, the burden of proof had to be met. There had to be, of course, substantial evidence to support the need for the extreme risk protection order. But what this also shows us is that there are a lot of situations in which there is a high risk profile for an individual, and ERPO is being sought and ERPO is granted, and the firearms are temporarily removed. So I just want to share a few reflections on the ERPO experience to date. This is a very high level picture of what we see around the country in the states that have this law. We see great variation in the implementation, the use of ERPO laws, both among states and within states. And what I mean by that is you could have a state that hardly ever uses an extreme risk protection order, and you could have a state that uses it all the time, but the variation depends on where in the state you're looking. So there could be County A that uses the 90% of the ERPOs are in County A and maybe 10% are in the remaining counties. Or you might have the variation being a state that uses it a lot, a state that doesn't use it at all. But what we know from this is that use tends to depend on having a champion on the ground, having someone who thinks this law is important, understands how it's to be used, prioritizes training. So that is really critical overwhelmingly to the ERPO success around the country. We also know that even though most states have expanded petitioners beyond law enforcement, petitioners are almost always law enforcement. The exception there would be a state like Maryland, where we see more of a 50-50 split between law enforcement and civilian petitioners. We rarely see healthcare providers or clinicians petitioning, but there are situations, just like with family and household members, where they initiate that contact to law enforcement that then leads to an extreme risk protection order that is petitioned by law enforcement. We also mostly have descriptive studies to date. I talked about Dr. Zioli's slide, research on the slide prior. We have a lot of examples of how ERPOs are being used, but we don't have a lot of qualitative studies yet, although there are a lot of studies in progress. We see ERPOs being used in response to many different types of violence: mass shooting threats, suicide, interpersonal violence, domestic violence as well. And there is a real critical opportunity now with the Bipartisan Safer Communities Act. This was a law that was signed by President Biden in, I guess, June 2022. Now it's almost been a year and a half, or has been a year and a half. And one key component of the Bipartisan Safer Communities Act was the availability of funding to support states that have this legislation in implementing it. To date, most of the implementation efforts have largely been unfunded or minimally funded, or really dependent on local funding and, again, local champions to make sure it happens. There is now federal funding available for at least 5 years for states to implement all types of crisis intervention orders, including in states that have it, an extreme risk protection order. So now I just want to quickly highlight a few case studies. I know this is a lot of text. You'll get a copy of our slides, and of course this webinar is being recorded. If you want to more closely reference any of these case studies, we also have the sources at the bottom. But what I want you to take away from the next 3 slides is that ERPOs can and are being used to prevent all different forms of violence. This example here is about partner violence, mass violence, a situation where a woman was worried about her intimate partner, and was worried about the safety of her son as well. And she was able to get police to file an emergency ERPO in California. This is where this took place. So it's called a gun violence restraining order, and get the firearms removed in that situation. And again, there's quotes here about the direct threats that he was making. In this example from Maryland, a high school student was texting a friend saying that he was going to kill people at school, was going to recreate the Columbine school shooting, essentially. And in this situation, again, this threat was reported, the ERPO was filed, was granted, firearms were removed, and this shooting threat did not materialize, did not happen. And then finally here, this is from Washington State. This example was provided in testimony by Kim Wyatt, a senior prosecuting attorney in King County, who talked about a situation where the respondent of the ERPO was writing suicide notes detailing his plans. And this situation, again, resulted in an officer getting an ERPO and having his firearms removed. So I'm going to turn it over now to Chelsea to give it an overview of Michigan's law specifically.
Great, thank you, Lisa. So let's go ahead and get into it. If you want to go to my first slide. So I'm going to go through the details of Michigan's extreme risk protection order law. Some of this is going to be a little dense. It closely tracks the statutory language. And so follow with me. You'll get these slides. You can pull the language yourself from the statute. But I want to make sure that folks really have a sense of some of the details of Michigan's law and the legal parameters around it. So Michigan's Extremist Protection Order Act was enacted in May of last year. It will go into effect on February 13th. So like Lisa said, we're about 2 weeks out from the law going into effect. And then I've got the statutory citation there. This is where the law is codified if you want to go and pull the statutory language. Next slide. So who can file an ERPO petition in Michigan? The statute clarifies that the following people can file petitions directly with the court. So a current or former spouse of the respondent. The respondent is the person against whom an order is sought. So their current or former spouse, someone who has a child in common with the respondent, an individual who is in a current or former dating relationship with the respondent, someone who currently or previously resides in the same household with the respondent, a family member, which is defined as a parent, child, sibling, grandparent, grandchild, aunt or uncle, or first cousin. Any of those individuals can file a petition, a legal guardian, and then law enforcement officers and certain designated healthcare providers. So this is the universe of individuals who can file the petition directly with the court. Like Lisa said, in most states, we see that law enforcement officers file the vast majority of these cases directly. But Michigan has created a system through which a pretty robust group of non-law enforcement petitioners can also file. Next slide. In terms of healthcare providers, the following healthcare providers may file an ERPO petition. So a physician, a physician's assistant, nurse practitioner, a certified nurse specialist, or a mental health professional, as that's defined in a separate section of the code. So those are the healthcare providers who are eligible to file an ERPO petition directly with the court. As Lisa said, in some states where healthcare providers can file petitions, they will sometimes file directly, or they will sometimes work with law enforcement for law enforcement to file the petition, but healthcare providers in Michigan do have the option of going directly to court themselves. The statute does clarify that a healthcare provider may only file an ERPO petition if doing so does not violate HIPAA or physician-patient confidentiality. I did want to highlight that the HIPAA privacy rule does allow healthcare providers to disclose protected health information in circumstances such as the filing an ERPO proceeding. And if folks are interested in more details around that exception, we can provide that afterwards. But there is an exception to the HIPAA privacy rule that should allow physicians to be able to participate in ERPO petitions and ERPO proceedings. Next slide. So a complaint for an extremist protection order. So in Michigan, the statute refers to a petition as a complaint. The complaint must state facts that demonstrate that an ERPO is necessary because the respondent can reasonably be expected within the near future to intentionally or unintentionally seriously physically injure himself, herself, or another individual by possessing a firearm, and has engaged in an act or acts or made significant threats that are substantially supportive of that expectation. So that is a mouthful, but I thought it was important for you to have the actual statutory language to really be able to see what courts are going to be looking for when they are evaluating an ERPO petition. And it's really important to emphasize that a petition has to include specific facts and details. There needs to be enough information provided to the court for the court to be able to really make an assessment of whether this standard has been met. The petition should also indicate if the respondent currently owns any firearms. So if the petitioner knows or has reason to believe that respondent owns firearms, they should include that information in the petition with whatever level of detail they have. And so if they know how many firearms, if they know where those firearms are usually stored, all of that information should be part of the petition if the petitioner knows that information. However, it's not necessary that a respondent already be a gun owner in order for an ERPO petition to be filed. So like Lisa said in the introduction to ERPOs generally, if the court issues an extremist protection order, it will order the respondent to surrender any firearms that they already own, but it will also prevent that individual from being able to purchase firearms. And so, again, it's not necessary that a respondent already own firearms in order for an ERPO petition to be filed. Once the complaint's been filed, the respondent must receive notice of the petition and of a hearing and be given an opportunity to be present at the hearing and to present any of their own evidence in opposition to the allegations that have been made in the petition. Next slide. So the emergency ERPO process in Michigan. So when an ERPO petition is filed, if there is an immediate risk of harm, the petitioner can also request that a short-term emergency extreme risk protection order be issued immediately before the respondent receives notice of the proceedings and before there can be a hearing. And in Michigan, the way the statute contemplates this emergency process is that if there is a risk, an immediate risk of harm such that waiting for a hearing creates a danger, or if there is reason to believe that serving the individual with notice of the hearing may itself precipitate some kind of dangerous interaction, then the court can issue an emergency extreme risk protection order before there is an opportunity for a hearing. So if the petitioner requests an emergency order, the court needs to rule on that request within 1 business day. So it needs to rule on it relatively quickly. And then if the court does issue an emergency order, then the respondent can request to have a hearing, and that hearing needs to be held within 14 days. So again, the emergency order really is intended to be a very short-term, very temporary order. Next slide. So the statute lists out a number of factors that a court must consider if they are present when evaluating a petition for an extreme risk protection order. And so I've listed some of them out here, but the factors that a court must consider include history of use or attempted use of physical force, any evidence of mental illness or serious emotional disturbance that creates a risk of harm to self or others. As Lisa said at the outset, evidence of mental illness is not necessary, nor is it sufficient when it comes to issuance of an extreme risk protection order, but such evidence is a factor that a court must consider if it is present. Other factors include previous extreme risk protection orders or other kinds of protective orders that have been issued against the respondent and any violations of those kinds of orders, any previous convictions or pending criminal charges for certain designated offenses that are listed out in the statute. These are offenses generally that involve physical force, that involves some kind of assaultive conduct, stalking, those kinds of offenses. Evidence of recent unlawful use of a controlled substance or abuse of alcohol. Previous unlawful possession, use, display, or brandishing of a deadly weapon, evidence of an acquisition or an attempted acquisition of a firearm or a deadly weapon within the previous 180 days. And then the court can consider any other information that it finds to be reliable, including a statement by the respondent or any relevant information provided by family and household members. Next slide. So if the court grants an ERPO, a few things will happen. The court will give the specific reasons that it decided to grant the order. So the respondent will be made aware of why the order was issued. The order will advise the respondent that they are prohibited from possessing or purchasing firearms while the order is in effect, and that they also must surrender any license to purchase or concealed pistol licenses that have been issued. The court will advise the respondent of the potential penalties for violating the order, which I'll talk about in a minute. And then in Michigan, an extreme risk protection order will be issued for a duration of 1 year. And it may be renewed upon request and after another hearing. So at the end of the 1 year period, a petitioner can go back to court and needs to demonstrate again using the same standard that the individual still is in need of an ERPO and that the legal standard continues to be met by the evidence that's available. The respondent can request to modify or rescind the ERPO once every 6 months. And so if the respondent has evidence to demonstrate that the risk that was present at the beginning of the proceedings is no longer present, they can go back to court and present that evidence and ask for the ERPO to be modified or rescinded prior to its expiration at the end of 1 year. And then the court will direct a local law enforcement agency to report the order to the FBI so it can be included in the National Instant Criminal Background Check System. That is the system used for firearm purchases. And so that's the mechanism mechanism through which an ERPO will ensure that an individual is not able to purchase firearms while it's in effect. Next slide. So when the court issues an ERPO, the court will decide whether the respondent needs to immediately surrender any firearms that they currently possess, or whether they have 24 hours to surrender their firearms. The statute builds in a presumption that unless the petitioner is a law enforcement officer or a healthcare provider, the respondent will have 24 hours. But that is a determination the court will make as to when the firearms need to be surrendered. If the court does order surrender immediately, it'll also issue a search warrant that would allow law enforcement officers to search the locations where the firearms are believed to be stored. However, officers are not allowed to execute that warrant unless the respondent fails to voluntarily comply. So the individual needs to be given the opportunity to comply voluntarily and surrender their firearms before law enforcement can use that search warrant to go in and look for the firearms. And then the court can allow the individual to surrender their firearms to a licensed gun dealer instead of to local law enforcement. And the statute requires local courts to develop a list of approved gun dealers for this purpose. I think that list will probably not be ready by the time the law goes into effect, but as the systems kick up in local jurisdictions, there will be this opportunity to surrender firearms to licensed gun dealers instead of law enforcement. Next slide. So when an ERPO expires or is terminated, the individual can reclaim their firearms. The law enforcement agency or the gun dealer who's storing the firearms must conduct a background check before returning those firearms to the respondent to confirm that they are not prohibited from possessing firearms for another reason. So to make sure that there was not something else that happened during the year that that ERPO was in effect that rendered the individual prohibited from gun possession, such as a felony conviction or the issuance of another qualifying restraining order. The law enforcement agency that seizes and stores firearms pursuant to an ERPO is not liable for damage to those firearms unless that damage is the result of a failure to exercise reasonable care. And so that's another piece that was included in the statute as well. Next slide. And then the last thing I wanted to just go through is there are penalties included in the statute. A petitioner who knowingly and intentionally makes false statements to the court in connection with an ERPO proceeding in an ERPO petition can be guilty of a misdemeanor for the first offense and for a felony for any subsequent offenses. So there is a penalty in place for abusing the ERPO process. And a respondent who fails to comply with an ERPO can be guilty of a felony and subject to escalating penalties based on whether this was a first or a subsequent offense. And the ERPO can also be extended for an additional year if there's a violation of that order. And then finally, there is a penalty in the statute for a third-party individual who knowingly gives a firearm to an individual who is subject to an extreme risk protection order. So those are the penalty provisions that are part of this. Again, an ERPO is a civil remedy, but these acts do have potential criminal consequences associated with them. And I think that is the end of my part. So I will kick it over to Spencer.
Thanks so much, Chelsea. So now we're going to talk a little bit about what the model approaches are to ERPO implementation, looking at the other jurisdictions around the country that have had ERPO laws in place for longer periods of time, and talking with experts around the country who are really leaders and ERPO champions in their jurisdictions to identify those best practices. So in December of 2022, after the funding was included in the Bipartisan Safer Communities Act, Everytown and the Johns Hopkins Center for Gun Violence Solutions hosted a convening where we brought together ERPO implementers from around the country to talk about best practices. What is it that's making ERPO work? And then we were able to come up with this report, Promising Approaches for Implementing Extreme Risk Laws. So like we said earlier, Lisa, Chelsea, and I, and our colleague Ruhi all worked on this. Please feel free to scan the QR code. We'll also throw this link up in the chat for you all to access. But we're going to go through this report now and talk about what are the recommendations that we identified in this convening in this report. So in the report, we broke our recommendations down into 6 key areas, starting kind of with the infrastructure that you need in a jurisdiction for ERPO to be successful, and then kind of going through the process, looking at the pre-petition inquiry. What does the petition process look like? What does the service look like and the removal of the firearms look like? Thinking about what needs to be in place for non-law enforcement petitioners, and then how are we ensuring transparency and accountability? How are we collecting data and keeping things consistent? Next slide. So to start off with the state ERPO infrastructure, this is largely where I would imagine folks being right now in Michigan as you're building out your ERPO law. So one of the first things that we recommend is designating a statewide ERPO coordinator. This is someone that can really be an expert for ERPO in your state and can serve as a resource for others around the state, especially where you have rural areas or folks that maybe don't have the ability to work with others in their jurisdiction on ERPO as much. Having a statewide coordinator to ensure consistent rollout, be able to answer questions and kind of serve as that conduit and that navigator for folks around the state is really helpful. And then also creating a statewide ERPO task force. This is where you can bring together folks from a variety of disciplines who are all really important to ERPO succeeding. So an ERPO task force could include folks from law enforcement, the judiciary, prosecuting attorneys, social workers, and really thinking about what does it take from all of those different components for ERPO to succeed. Also implementing statewide data collection protocols. It's really important as data is being collected that it's being collected consistently. Sorry about that. And we know that unfortunately, computer systems don't always talk to each other in a way that's helpful. And so being able to have that consistent data collection across jurisdictions is really helpful. It's also helpful to develop a statewide ERPO training curriculum so that everyone is being trained on ERPO consistently around the state. This is also a way that you can build up those resources for folks around the state and have that centralized resource. It's also important to increase awareness of ERPO laws through education and outreach efforts. So I'm glad you're all here today learning about Michigan's ERPO law. It's really important that the education and the outreach really target the key implementers. So who are the folks in Michigan that need to know? It's going to be, like we said, law enforcement, attorneys, mental health clinicians and providers, social workers. Who are those folks that are going to be the ones individuals are reaching out to when someone they're worried about is in crisis? Those are the folks we want to know, is that really targeted outreach. And then considering options for a state law enforcement agency to file for ERPO petitions. Is there the possibility for a statewide police agency to file where you might have a jurisdiction that's not, that the local law enforcement aren't using ERPO? This can kind of be a way to fill that gap. Next slide, Lisa. So the local ERPO infrastructure, this is on the ground, the folks that are really responding to the petitioners and the respondents and helping the folks in need. So designating ERPO leads and law enforcement agencies and prosecuting our county attorney's offices. This is going to be really important to do, especially in larger cities or more urban areas where you're going to have a larger police force. You can dedicate staff to really focus their time on ERPOs. We've seen in some jurisdictions around the country having really developed out these ERPO and crisis response teams who are able to work on ERPOs, and they're really able to have that specialized knowledge on working on ERPO and responding. And so having that specialized knowledge is important for those folks, as well as dedicated ERPO judges. So the judicial officers that are presiding over ERPO cases, having a really good handle on the law and the criteria, as well as just how these cases often work and what are the issues and barriers and questions that come up in court. Having that specialized knowledge is so important. I think in smaller jurisdictions or more rural areas, you might not be able to designate leads in the same way in law enforcement and prosecutors' offices, but you can still work on having that specialized knowledge, having that go-to person in those jurisdictions. It's also great to create a local ERPO working group or coordinator to facilitate cooperation. So when you have all of these different folks working on ERPO, it's really helpful, again, on the local level to have that conduit so that the law enforcement and the prosecuting attorneys and any social workers that are involved or any domestic violence advocates that have questions all have that local resource to turn to. And so that local working group or coordinator is really valuable. We also love to see a local advocate to guide respondents and civilians involved in the ERPO process. We've seen this play out in King County, Washington, for example, where they have the local ERPO advocate. And this person is akin to a domestic violence advocate almost, where they're working to make sure that respondents and their families have their questions answered and that they're also connected to any other resources or relief or help that they might need. So if a respondent is dealing with mental health issues or homelessness, making sure that that individual is connected to the resources to address the underlying issue so that they're able to get the assistance that they need. It's also really great to implement a local ERPO training curriculum. And so, you know, if you have a statewide curriculum, that's great. If you don't, it's also important to create your own local ERPO training curriculum or to build on the statewide curriculum to really focus on what is going on in your jurisdiction and able to talk about what the local practice is and the local relationships and how, what exactly is the process on the local level? Who do you talk to? Who do you go to with questions? What's the address of the court? All of those nuts and bolt details on the local level are also great. It's also important to develop protocols so that you can make sure that information on ERPOs is being included in the background check databases in NICS or in CIC. You want to make sure that that information is being shared and that you know who is sharing it and that it's being consistently shared. And that can get a little bit confusing potentially for folks if you're not the ones familiar with those databases. So please feel free to follow up with Lisa or Chelsea and or myself after this presentation if you have questions about the background check databases and making sure that your ERPOs are entered there appropriately. Next slide, Lisa. So before you file for the petition, there's some pre-petition questions that we have and considerations we have here. So it's great to develop a process for assessing ERPOs along other potential tools. So is ERPO the right tool in this situation and in this circumstance? Or is there another more appropriate tool? Lisa talked earlier about the difference between ERPOs and domestic violence protection orders. Is ERPO the right tool or would a domestic violence protection order be more appropriate? Is ERPO the right tool or does this individual need to be on a mental health hold or do they need this and this, right? So it's really important to look at what are all of the remedies and relief out there in the civil world and then making sure that this is the right tool. Not every case is going to be appropriate to file an ERPO in. And so just being really thoughtful. It's also great to consider that ERPO may be the right tool in place of a criminal case or in addition to. So we've seen different jurisdictions use ERPO differently. We've seen some jurisdictions using ERPO as an alternative to the carceral justice or the criminal justice system, and where something might have 10 years ago in that jurisdiction been a criminal charge, they're using ERPO instead, and they're taking away the guns, they're addressing why the person used the guns in that way, and then not having a criminal case. That may not be appropriate in all situations, right? But it's just something to think about. Do we want to have the ERPO in the civil case here, knowing that if the individual violates the ERPO, that could become a criminal case? or is a criminal case here more appropriate? And that's going to largely be decided, right, by the petitioners, depending on them, and then also the prosecutors if they're getting involved in the case. It's also important, like we said in the last slide, to connect respondents with service providers so that they're able to get the appropriate resources they need. This is almost a silly example, but we were talking with an implementer in a jurisdiction, and the individual respondent had been in crisis and had severe PTSD. They were a veteran, but the straw that broke the camel's back was they couldn't afford to buy dog food for their dog. And that's what led to this real suicidal crisis. And so they connected the man with someone who was able to buy him dog food. They also did the ERPO, right, and took away the guns, but it was that connection with the social service provider to meet this individual's totality of needs that really helped to de-escalate the situation and get that person on the right track, so that there wasn't a need for an ERPO again in the future, and that they were able to address this moment of crisis now, and then also be thinking ahead so that nothing else arose in the future. It's also important to think about, what are you going to do when a person in crisis possesses a gun unlawfully? Are there going to be criminal charges for unlawful possession of a firearm, or is there going to be some sort of amnesty provision? And are you going to decide that with your with a policy that you have in place? It's really important to think about this before you have the case in front of you and you've got the person in crisis and you're really quickly trying to decide how to respond to this individual in crisis. It's also critical that you create supports for non-law enforcement petitioners in the petitioning process. You want to make sure that folks besides law enforcement who can petition have all of the information that they need and are empowered to fill out that petition. Especially when you have family members or folks that might be really emotionally affected by these cases, who are filing for a loved one. That can be a really, really tough situation and set of circumstances. And so we just want to make sure that they have the support they need, whether that's an ERPO advocate, whether it's that local coordinator they can turn to. You want to make sure that when they go to the court and they go to the clerk's office and are saying, I think I need a form because I don't know if this person should have a gun, you want them to have the language and the support they need to fill out a petition and be empowered and know what's going to happen in the process as much as possible, right? Things could change. You don't know what the judicial officer is going to determine, but you want them to be really empowered in the process. Next slide, Lisa. So in the process, having clear and accessible court forms to facilitate the filing. I don't believe that Michigan's forms are up and running yet. Hopefully they will be very, very soon. But it's really important to have clear and accessible court forms where possible, translated into different languages that are used by the local communities so that everyone is able to access these forms. It's also really helpful to create a 24/7 process where you can for folks to consider temporary petitions. I'm an attorney and I practice mostly in Maryland, working with domestic violence victims. And in Maryland, folks could petition 24/7, 365 days a year, because unfortunately, crises and trauma also happen after business hours and on weekends. And so where possible, letting folks access this as much as possible around the clock is very helpful. Next slide, Lisa. So service of the orders and firearm dispossession. I think this is where when Lisa and Chelsea and I present to law enforcement, we often get questions about what this is going to look like, and especially the risks that might be involved for law enforcement when they're servicing these orders. I will say, from what we've seen, we don't have any research documenting this yet, but anecdotally what we've seen around the country is less of an escalation in service of ERPOs than we've seen in the service of domestic violence protection orders. But there's a few things that we really recommend to keep things de-escalated and help keep everyone safe. So creating a protocol for service of ERPOs and firearm disposition that relies on specially trained officers. We want these officers to know what they're doing and to be able to have tough conversations in a warm and friendly way. We talk a lot about warm service, where possible, not going in with a SWAT team and 12 squad cars all with their lights and sirens on. There might be a few situations where that's necessary, right? But if you can do that warm service and have law enforcement having that conversation with the respondent for why the order is being served and what they have to do, and having that warmer approach can really go a long way. But having that protocol in place is really important. It's also great to prepare an individualized plan when working with respondents to make sure that you're engaging their broader support system. So we did a site visit last fall, Lisa and I did, and we were talking with law enforcement, and before they served the respondent with the ERPO, they reached out to his mom, and she flew in from out of state so that she could be there. And this was an adult, right? But they knew that that was really the only support system that he had. And engaging that support system was really important in helping him be stabilized. So thinking about what can you do to support this individual so that even when their firearms are removed, they're feeling supported. It's also really important to develop protocols for non-compliance with ERPOs. So what happens if someone will not surrender their firearms? What happens if someone says that they've surrendered their firearms, but you have evidence that they've not? Someone, is saying, oh, I gave up all of my guns, but a family member is saying, actually, I think that they had 5 and they only surrendered 3. So what do you have in place to ensure non-compliance? And whether that's search warrants, compliance hearings, there's a lot of different strategies that you could put in place there. And then implementing standard compliance measures to ensure that firearms are promptly surrendered. So one thing we've seen be really successful is having compliance hearings a week or two after an ERPO is issued, where the respondent has to go back to court and testify under oath that they've surrendered all of their firearms, or also signing an affidavit that they've surrendered all of their firearms. In jurisdictions where we've seen third-party transfer of firearms allowed, also requiring that third party to come to court so that everyone is on the same page in front of a judge and under oath. And we're really ensuring that belt, suspenders, and safety pin approach to compliance. Next slide, Lisa. It's also really important to think about, what do you do if someone has access to guns owned by other individuals? So if someone's living in a household, if you have an 18-year-old living at home with their parents, and the parents have guns that aren't registered to that 18-year-old, excuse me, making sure that there's a process in place for those guns to be removed from the home, and developing that protocol. Sorry, I'm getting over a little bit of a cold here. You also want to have multiple options. Excuse me. So sorry, y'all. For storage of those weapons, whether that's with the law enforcement agency or a gun dealer, having those safe storage options available. And then lastly here, and Chelsea talked about this a little bit in her presentation, having clear protocols for what happens when the ERPO expires. How are those firearms returned? What checks are in place to make sure that the ERPO doesn't need to be continued? Who is notified that the respondent's firearms are being returned? But having a very clear protocol and a process so that everyone is on the same page is very important here. Thanks, Lisa. So special considerations for non-law enforcement petitioners. You want to offer customized training and outreach for non-law enforcement. So if you have other folks petitioning, you want to think about, what are the the barriers that they might be experiencing, what are the supports that they need, what are the questions that they might have, what are the logistics of having them file and work on ERPO. And so having that customized training and outreach for different audiences is key. It's also helpful, like we said, to have these ERPO advocates that can work with the respondents. You might have the same ERPO advocate that could also work with civilian petitioners through the process and help support them. But just making sure that everyone has the support they need to file appropriately, make sure that the correct forms are filled out and filed, that all the correct boxes are checked. And again, that you're using the correct tool. You don't want someone filing for an ERPO when there's really other relief that's more appropriate. And having ERPO advocates can be really helpful in navigating that process. And then having those protocols between courts and law enforcement to make sure that these ERPOs are served. Even when you have a non-law enforcement petitioner filing for an ERPO, it's still going to be appropriate for law enforcement to be serving these ERPO petitions and managing the surrender of the firearms. And so making sure that those protocols are in place. And if there's information that the petitioner has about what kind of guns are owned, where they're stored, making sure that that information is contained in the petition so it can be accessed by law enforcement, and so that you're having that sharing of important information that everyone needs when responding to the respondent. Next slide, Lisa. We also want to ensure that, like I said earlier, there's the consistent data collection and information sharing to enable oversight and research. We work in a lot of different jurisdictions around the country, and sometimes it's easier or harder to get records of what information, what are the reasons that the ERPO was filed, what are the demographic information about the petitioners and the respondents. We want to make sure that ERPO is not being underused nor overused, right? And so having standard data collection helps us better research ERPO and make sure that it's being used appropriately, and helps us better understand what are some opportunities for us to use ERPO in situations where we could be saving more lives. And so having that standardized data collection across agencies and across the state is really key. And it's great to build in that infrastructure from the beginning. You want to build that in before everyone has started collecting information in a variety of different ways. You want to create a process for regular review of the local programs that involves all key partners. And so, this is to some degree, an iterative process as you're learning with your state's new law in place. You want to make sure that everyone is being brought together. We talked about that ERPO task force earlier, really thinking about what are ways we can strengthen the process, what are ways we can communicate better, are there staffing needs that we've identified that we can fill. Having that regular review of local ERPO programs is great, and it's something that we've seen being successful in a lot of different contexts. Just looking at how tools are used and bringing together community partners to think about how can we work together better, how can we coordinate better is really critical. And then publishing an annual statewide ERPO report. This is helpful for folks like all of you and other folks out in the field to understand how is this being used. We've seen a lot of different uptake, going back to my home state of Maryland, a lot of different uptake across the state. But ERPO has been used in every county in Maryland, but we see higher rates of usage in some counties than others. So having an annual statewide ERPO report can help you understand, where is ERPO being used? Where is it not being used? Where are we seeing it being used more successfully, and allows for that information sharing across jurisdictions so that everyone is able to just learn from one another. And if you have a statewide ERPO advocate, they could potentially take the lead on that annual statewide ERPO report, right? This is also helpful for you to share with lawmakers, right, who helped create the ERPO law. You can take this back to them and share. Or when you're looking at funding for ERPO programs in your state, having this ERPO report showing how ERPO is used, or hopefully this doesn't happen, but not used, is helpful for you to think about how can we make tweaks in implementation and practice to support folks all around the state. And then Lisa is putting up here again a copy of our report, which again, I just sped through, but I really hope that folks will download a copy of this for your review. It's dense, but has a lot of great information. It also has an appendix, which has a chart of different states' laws, if you're curious to see how Michigan compares with petitioners or other factors in your law. That's included in an appendix there. And Lisa also put the link to this report in the chat a few minutes ago.
Great. So I think we'll leave our email addresses up for a second. We still have 10 minutes left. So there were about 20 questions in the Q&A that all of us have been answering as we've been going. So please check those out. But I also would encourage folks to put questions in the Q&A right now, and we can maybe even answer some of those live, given that we have a little bit of time left over. And then I will stop the screen sharing. But before I do that, please copy down all of our email addresses. And I don't know, Chelsea and Spencer, if there's any question in particular in the chat you thought we should also answer verbally, we could do that.
I didn't see a question in the chat, but I think, considering that we've got the attention of lots of advocates in the state, a question that I would pose is what do we suggest that kind of folks be doing in their communities right now to help support the effective implementation of this law as it gets ready to go into effect in 2 weeks? Do you guys have any kind of advice or thoughts about what advocates could be doing right now?
Want to go, Spencer?
Sure. So I think it's really important to make sure that folks in your jurisdictions are aware of the law and thinking about what is being stood up in your jurisdiction. So I know we're all waiting on the court forms, but once we have those, talking with folks in leadership and local law enforcement and prosecuting attorneys' offices to make sure that they're aware and able to work on implementing these laws effectively, and really reaching out to all of the different petitioner groups to make sure that they're aware of the law and really focusing on those folks from the start. And then also thinking, I see Chelsea put this in the chat a little bit about the Bipartisan Safer Communities Act funding. There's $750 million over 5 years to support ERPOs and crisis intervention funding around the country. And so Michigan gets a slice of that pie. Michigan's plan for year 1 did not include funding for extreme risk protection order implementation. I think in large part that's probably because the law was passed and going into effect after the state plan was kind of being written. So thinking ahead in subsequent years, could that funding be used to help with ERPO implementation? I see someone put in the chat education. That's so key for working on supporting. I would implementers and having successful ERPO rollout, but I would say especially at the beginning phase, you want to really focus on those key implementers and really thinking about targeting that education because it's great for the general population to be aware as well, but that's probably going to be in a later phase.
Yeah, that's a great point. The only thing I would add for more of a law enforcement specific audience, or if there's advocates on the call that work with law enforcement, is one thing we've seen as a model of success from Maryland, where Johns Hopkins is based, is that prior to the law going into effect, there was a sheriff in Maryland who familiarized himself with the law, prioritized its implementation, and actually took it upon himself to be the statewide trainer. And what he did was a sort of train the trainer model where he would go around to train police chiefs in the counties in the state, and they would then disseminate that information to their jurisdictions. And so, of course, it was a lot of time and effort on him to visit all of the counties throughout the state of Maryland. But then at least he had built up this other group of champions who then kind of trickled down that information to all the detectives and sheriffs and other law enforcement in the state. And that seems to have worked well. It could also be why Maryland is one of the only states that's actually used an ERPO law in every single county within the state. That's pretty atypical. There are typically states, like I said at the beginning, that have sort of model jurisdictions. Take California, for example, you might see a large proportion of those orders out of San Diego, maybe not as many, I'm making this up, maybe not as many in Alameda County. And so it's important that that information really be spread far and wide, because we know that violence can occur all throughout the state. And so Maryland's a good example of a place that got education early, and this Sheriff Popkins spread that information far and wide and trained law enforcement throughout the state. There's also a question, there was a question in the chat about the court forms. So unfortunately, last that we heard, those will not be available before the law goes into effect on February 13th, unfortunately. I do think this is potentially a place where advocates can push a little bit and, reach out to the courts and even offer guidance if you feel as though you're in a position to support it, because this should not be starting from scratch for a state like Michigan. There are 20 other states in the District of Columbia that have court forms up for the most part. Minnesota got their court forms up before the law went into effect on January 1st. They have a whole webpage with the petition, with affidavits, with the evidence needed to present to judges, and a whole host of other information in an FAQ about their law. That material, for the most part, for Michigan, as you can see, because it's in our presentation, already exists. So there shouldn't be a real need to, start from square one. We don't need to reinvent the wheel where material already exists. So if you have a contact in the court, you want to offer guidance, you want to offer any of us as guidance, or Dr. April Zioli as guidance, some of those other experts on ERPO laws, please, I won't speak for any of them, please feel free to do that for me, because we want to help and ensure that these forms are created as expeditiously as possible, because come February 13th, people need to know that information, actually need to know it starting now.
I see another question in the chat here from someone asking about the timing element and wondering why ERPOs typically last for 6 months to 1 year. So ERPOs were created, and the modern day ERPO was created in 2014, and based off of domestic violence protection orders, which also often have durations of 6 months to 1 year. So what we're seeing in most instances is ERPO laws that closely mirror the domestic violence statutory and timing scheme. We also know, based on the consortium research that came up with ERPOs, that it's not enough just to remove the ERPO for a day or a week if you're looking to address those underlying risk factors and concerns. And so having an ERPO that lasts for 6 months to 1 year is still temporary, right? Someone can get their firearms back after that very limited and concrete amount of time, but it allows for an advocate and the other folks involved to make sure that that individual's holistic needs are being met before the firearms are returned.
And I will just add to that point, Illinois, they have a ERPO law called a firearm restraining order, a FRO. Their final FRO was a 6-month FRO. They have since extended it, so it can last up to a year. So this in some states has been an iterative process where maybe they're looking at the evidence and saying it's really not long enough to have it be 6 months. Of course, you don't want it to be indefinite. That's not the purpose of the extreme risk protection order. But there are a lot of situations in which the risk does not subside after 6 months. And a state like Illinois has taken that into consideration and actually extended the length of their final order as a result. Any last words, Spencer, Chelsea? We have 1 minute. I think we did the timing pretty well here.
I would just encourage folks to reach out to any of us if you have any follow-up questions, or if we can support anyone here in your ongoing implementation efforts, that's what we're here, is to be an ongoing resource.
Okay. Thank you all very much. This recording will be available after the event ends today.